This is one of the best self-owns I've ever seen. Oh my God. Penny, who I think is a male, I don't know, goes by the handle at PR Shirts, is not too happy with the new Florida law instituting the death penalty for child rape. Penny says, the amount of people not understanding this is going to be used to kill trans and queer people is making me lose my mind. Oh my God, what the hell are you saying, Penny? Really? That's what you want to run with? Oh my God. And Penny is getting slaughtered on Twitter, and for obvious reasons. This implies very strongly that trans and queer people are prone to child rape. Now, I'm not saying that, okay? That's not my message. I'm just saying that Penny's message on Twitter certainly implies it. And Penny is getting ratioed something horrible. Okay, but let's talk about this new death penalty for child rape that Florida has instituted. What about it? Well, guess what? The Constitution might be a problem here. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnny Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnny Walker Dread Show.
Okay, so here's the headline. Florida law allowing death penalty for child rapists goes into effect. All right. Florida's new law permitting the death penalty for pedophiles went into effect this week, the state's governor announced Tuesday evening. Florida's law allowing the death penalty for child rapists is now in effect, Governor Ron DeSantis said in a post on social media. The minimum sentence is life in prison without parole. In Florida, anyone who harms children in such a horrific way will never walk free. DeSantis signed HB 1297 in May, and the statute took effect on Sunday. The law states that a person who commits a sexual battery upon or in an attempt to commit sexual battery, I'm not certain how that works, injures the sexual organs of a person less than 12 years of age carries a great risk of death and danger to vulnerable members of this state. Okay, yeah, there's no disagreement there. And what I meant by I'm not sure how that works is if you injure the sexual organs of the person, how could it be attempted sexual battery? I don't know. Such crimes destroy the innocence of a young child and violate all standards of decency held by civilized society. Noting that the Florida legislature determined that both Buford versus State of Florida and Kennedy versus Louisiana, cases in which the Florida Supreme Court and the U.S. Supreme Court held that the death penalty for child rape was cruel and unusual, were wrongly decided and an egregious infringement of the state's power to punish the most heinous of crimes. And so there's these two cases out there. The Kennedy versus Louisiana case is the most pertinent to this particular law, so we're going to look at that. DeSantis said in May that he thinks the U.S. Supreme Court's 2008 ruling on capital punishment was wrong, suggesting that Florida's new law may enable the justices to reconsider the ruling on the matter. This bill sets up a procedure to be able to challenge that precedent, and we'll talk about that here in a moment, and be able to say that in Florida, we think that the worst of the worst crimes deserves the worst of the worst punishment. Okay, so here is the problem. Kennedy versus Louisiana basically says you cannot sentence somebody to death for child rape. I mean, it basically says that. On the face of it, Florida's new law is blatantly unconstitutional. However, there is an opening, and they kind of allude to it here. We're going to see what that opening is. So here's the Wikipedia entry on Kennedy versus Louisiana. It's good enough for our purposes. So Florida's new law appears to be unconstitutional. By the way, the actual incident that started the whole deal here was especially heinous. Listen to this. Patrick O'Neill Kennedy, a man from Harvey, Louisiana, was sentenced to death after being convicted of raping and sodomizing his 8-year-old stepdaughter. 8 years old, okay? And a stepdaughter. But it gets worse. The rape, taking place in March 1998, was uncommonly brutal. It tore the victim's perineum from her vaginal opening to her anal opening, tore her vagina on the interior such that it separated partially from her cervix and allowed her rectum to protrude into her vagina. Good God. Invasive emergency surgery was required to repair these injuries. I mean, I've heard of some horrible things happening to kids. This is truly amazing. It's hard to even fathom that a person would do such a thing. We move on. Okay, so he was convicted in 2003, sentenced under a 1995 Louisiana law that allowed the death penalty for the rape of a child under the age of 12. On appeal, Kennedy challenged the constitutionality of executing a person solely for child rape. And the Louisiana Supreme Court rejected the challenge on the grounds that the death penalty was not too harsh for such a heinous offense. Okay, so this is important. The Louisiana Supreme Court applied a balancing test set out by the U.S. Supreme Court in more recent death penalty cases. Adkins versus Virginia and Roper versus Simmons, first examining whether there is a national consensus on the punishment and then considering whether the court would find the punishment excessive. So what they're basically saying here is that if enough states agree that the death penalty is appropriate, then that's a reasonable argument to establish that the death penalty does not violate the Eighth Amendment. All right? I think that's a little bit of an odd ruling, but whatever, that's the test. The Louisiana Supreme Court concluded that the adoption of similar laws in 5 other states, coupled with the unique vulnerability of children, satisfied Adkins and Roper. Okay, so what's the problem? Well, hang on. In the majority opinion, remember this is the Supreme Court ruling that the death penalty for child rape is unconstitutional, Justice Kennedy explained that the application of the death penalty had to rest on national consensus, and that as only 6 states permitted the death penalty for child rape, no such consensus existed. Okay? Never minding the issue about whether the death penalty is appropriate for the given offense. All right? I mean, that's another issue. In other words, is the crime so severe that the death penalty is warranted? Okay, that's a different matter. And of course, the Supreme Court held that it was not, but whatever, let's move on. In the majority opinion, it states the latter crimes may be devastating in their harm, as here, but in terms of moral depravity and of the injury to the person and to the public, they cannot compare to murder in their severity and irrevocability. Irrevocability meaning that once a person is dead, there's no way to right the wrong. The opinion concluded that in cases of crimes against individuals, the death penalty should not be expanded to instances where the victim's life was not taken. So there are 2 prongs to this argument. One, is the death penalty common enough among states to pass the Adkins test? And 2, is the punishment far more severe than what the crime warrants? But there's a problem. A central point of the court's analysis was the observation that child rape was a capital offense in only 6 states, and that no other state nor any federal jurisdiction authorized the death penalty for that crime. Unfortunately, that was wrong. 3 days after the case was decided, Dwight Sullivan, a colonel in the United States Marine Corps Reserve, who was the chief defense counsel for the Office of Military Commissions, noted in his CAA flog, whatever that is, on military justice that Congress had revised the Uniform Code of Military Justice in 2006 to add child rape to the list of offenses punishable in the military by death. None of the 10 briefs filed with the court, and neither the majority nor dissent mentioned the provision. On July 2nd, 2008, Linda Greenhouse of the New York Times highlighted Sullivan's post, bringing the issue to national attention. After the error was discovered, supporters of the law, including the governors of Missouri and Louisiana and 85 members of Congress, petitioned for rehearing. However, on October 1st, 2008, the Supreme Court decided 7-2 not to revisit the decision. So what's this all mean? Well, suppose that some dude rapes a child and is convicted in a Florida court and sentenced to death. All right. Obviously, the defendant's lawyer is going to file an appeal, stating that the Supreme Court has already ruled that the death penalty for child rape is unconstitutional. Well, the prosecution is going to fire back and demand that the Supreme Court revisit this earlier decision not to rehear the case based on this technical error. So will the Supreme Court go back and say, the earlier Supreme Court decided against rehearing this case based on this technicality, but you know what? We'll go ahead and rehear it after all. And they can then go in, reestablish the death penalty for child rape. So it's going to get interesting. Now you may be wondering, Johnny Walker Dread, what is your view on this law? Well, this video is already too long. Stay tuned for a further video, and my answer might surprise you a little. Like my video and subscribe to my channel.